I am living flesh and blood, human. Government has taken that name and made an all caps name. So it will go to the Supreme Court, I promise you.
You understand that you've been charged in this case with cocaine, heroin, or another narcotic. The maximum penalty for that offense is up to 4 years in prison.
No matter what you do to me, I will get out of it, and there will be lawsuits.
This individual recently appeared in court and brought along a rather unusual set of beliefs. He claims he's not subject to any laws and that the legal system has no authority over him, a stance often taken by so-called sovereign citizens. The judge, known for being very firm, wasn't having any of it and firmly shut down his arguments. Let's take a closer look at how this hearing unfolded and how the judge handled it. Feel free to share your thoughts in the comments. Do you think this person was confused or simply trying to avoid responsibility? From the start, it was clear this man wasn't making much sense. He couldn't get through a sentence without...
First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir for the people.
Phoebe Muir on behalf of the people.
James Daly on behalf of the defendant.
All right. And
I never asked for an attorney. I said I would be representing myself in appropriate persona. This is just one way to railroad me. That's all. Get me in your jurisdiction.
All right. Mr. Daly, maybe you or Ms. Muir, maybe you can fill me in on the status of the...
Yes, Your Honor. I remember now. We did have an exam in this matter, and Mr. Mattson did represent himself at the preliminary exam. And then Mr. Mattson, then once it was bound over, did fail to appear here in circuit court. So now that he is incarcerated, whereas before he was not, I guess if we just go through whether or not he wants an attorney or still wants to represent himself, since we have had an exam in this matter, once he makes his intentions known on the record, then we can proceed with him still being pro per. But I would like to go through and make sure he is knowingly making that decision.
All right.
Knowingly.
Okay. Yeah, Mr. Mattson, just let me sort this out a little bit. Mr. Daly, have you been appointed as standby, or what exactly is your status?
I was appointed as standby, Your Honor. Mr. Mattson and we get along fine. He's a pleasant individual to talk to, but he wants absolutely none of my legal input. Basically, he has a theory that I don't believe is justified under the laws of the state of Michigan.
Okay.
And I've indicated that to him.
All right. We are back on the record then in the matter of Keeper versus Robert Mattson. Sir, you are Robert Joseph Mattson, correct?
I am an attorney for the all caps name Robert Joseph Mattson. I am living flesh and blood, human. Upper and lowercase, Robert hyphen Joseph :space Mattson. That is my name.
All right.
As shown on my birth certificate, live birth, that would be me, as understood that the government has taken that name and made an all caps name and tried to be to claim an account over that name, which to do business with.
Veering off topic, and some of his claims were just plain baffling. One of his main points was that his name being in all capital letters somehow changed the meaning of his identity in court, something that's actually just a legal formatting, standard, not a loophole or hidden code. He seemed to truly believe he'd found a way to beat the system, but the reality is far from that. He was in court, under the same laws as everyone else, and his arguments weren't helping him at all. Personally, I think the judge showed a lot of patience in this situation. At times, it seemed like the courtroom was turning into a debate club, with the man going on and on about irrelevant legal theories. He even misused terms like subrogation.
All right. Sir, do you understand that you have a right to be represented by an attorney in this matter?
I do understand that.
You also understand that if you want an attorney and you can't afford one, that you can tell me that and I would appoint one for you at public expense.
UCC 1-308, all rights reserved. By me answering and speaking to you at this time, doesn't mean that I'm in any way being given any kind of authority over my body to you at this time.
Okay,
Your Honor.
I will note, sir, your objection to my jurisdiction over you, and I will preserve that for the record. As
Your Honor,
discussed in your hearing on Monday, it is my position that this court does have jurisdiction over you, and I am going to proceed as such. And
yes, sir.
Again, your objection is preserved for the record, and if you would like to file an appeal, if that becomes necessary at a later date, you'll have the ability to do that.
Actually, I think I can do something a little quicker. I like to exercise my rights of subrogation, have the prosecutor file my right to subrogation, or certify my right to subrogation at this time. It's an undeniable right. Subrogation is the removal of a third party. It's in the laws, Black Laws Dictionary, 6th edition. Also the Bluebeard Law Dictionary, 2nd edition. That the removal of third party would be the prosecutor in this case.
All right. I'll note that request for the record and find that there is no right to subrogation in a criminal matter, and so I'm going to deny that request. Again, your objection will be noted for the record, and if you feel you need to appeal that decision at a later date, you will have the ability to do that. You understand, sir? You understand, sir? That you understand, sir? Sir, please let me speak. Do you understand, as I asked earlier, that if you can't afford an attorney and you want one, that the court would appoint one for you at public expense?
Do not want one. Thank you.
Okay.
I am not a U.S. citizen. I am sovereign. Separated myself from the U.S. government back in 2018.
We've covered that objection, Mr. Mattson, and I've ruled on it. Again, it's preserved for the record, and you can appeal it to the Michigan Court of Appeals if you would like to do that.
Which actually refers to something insurance companies do, not some secret way to win a case. Toward the end of the hearing, it became pretty obvious that this individual might be dealing with more than just confusion about the law. Even though the session was over Zoom, you could see he wasn't acting normally, fidgeting constantly, clenching his jaw and unable to focus. It wouldn't be surprising if other charges, possibly related to controlled substances, were also part of the case. If anyone watching is good at legal math, feel free to share what kind of sentence he might be facing. Because based on what we saw, this is not going to end well for him. What's fascinating is how...
Well, definitely, it's fraud. American jurisprudence guaranteed fraud. I studied it up and down. I know it all too well. So it will go to the Supreme Court. I promise you.
Okay.
As of right now, for the record, and let the record reflect any objections or denials that you keep denying me, that I'm asking you to file a 1090, an OID 1099 for the prosecutor, because the prosecutor is using my name to do business, and I will prepare the 1096 and the 1099A. So this court proceeding is going to go on and have a jury trial. There's going to be sovereign people, secure party creditors at my status, and also you're going to be filing that OID 1099 for the prosecutor.
Right, sir, do you understand that you've been charged with possession of a controlled substance in this case, and that the maximum penalty
I don't
for that
understand the
offense?
nature of the cause.
Sir, I'm going to ask you to let me finish when I'm speaking. I've done the same for you, and I'd ask you to do the same for me.
Your Honor. Yes, sir.
You understand that you've been charged in this case with possession of a controlled substance, cocaine, heroin, or another narcotic of less than 25 grams, that the maximum penalty for that offense is up to 4 years in prison.
I do not understand the nature and the cause of the crime.
All right, I'm advising you at this point that you have been charged with possession of a controlled substance, cocaine, heroin, or another narcotic of less than 25 grams, and that the maximum penalty for that offense is up to 4 years in prison. I'm also advising you that you've been charged with operating on a suspended license. A license has been suspended, revoked, or denied, that there is a second offense notice with that, and therefore the maximum penalty for that offense is up to 1 year in jail and or a $1,000 fine. I'm also advising you that you have been charged in this case with alcohol, open container in a vehicle, and the maximum penalty for that offense is up to 90 days in jail. This also carries a habitual offender second offense notice, which increases the potential penalty to 1.5 times the maximum sentence on the primary offense.
Admitted he seemed to these misguided ideas. It was hard to tell if he genuinely believed in them or was just stalling. He talked like he had discovered some hidden truth about the legal system, when in reality these theories have never held up in court. Ever. Still, he stuck to his story, even when it was clearly backfiring. That kind of misplaced confidence is almost impressive in its own way. Eventually, when the judge really started pressing him, he asked for a lawyer, a typical move in cases like this. Up until then, he acted like he didn't need one. You could tell the lawyer what...
As I've indicated, you do have the opportunity to consult with a lawyer if you wanted one, and if you can't afford one, I would appoint one for you at public expense. Mr. Matson, or sir, I believe you've referenced this already, but do you have any training in the law?
Yes, I do.
Would you tell me just a little bit what that training is?
Common law.
Okay, and have you studied that yourself?
Yes, I have, along with a couple other people.
Okay, you understand that the law in this case consists of criminal statutes that you're alleged to violate, the Michigan Court Rules of Criminal Procedure, Michigan Court Rules on Evidence, and any number of decisions from the Michigan Supreme Court and Court of Appeals which interpret those statutes and rules.
I understand that the Michigan Supreme Court offers 2 different types of courts. Common law court and a tribunal military maritime court, which this court is operating under, and they're not operating properly with me at this time.
All right, you understand that the prosecutor that's...
Sorry, go ahead.
You understand that the prosecutor that's going to try this case has been to law school, has had significant education and a number of years of experience and training in the law?
And that's perfectly fine.
All right. Do you understand that if you do represent yourself, you're going to be required to follow the Michigan Court Rules and the Rules of Evidence?
I'm going to be operating under common law laws, which that's what I should be under as common law. If this is not a common law court, I don't belong here.
All right. You understand that I know you've made that objection and then made it several times, but I'm going to conduct a trial on this matter that's going to require you to follow the Michigan Court Rules and the Michigan Rules of Evidence. You understand that?
Yes, sir.
And you understand that those rules are going to determine whether you can do things like ask certain questions of witnesses, admit documents, photographs, or any other evidence that you might have.
Yes, sir.
You understand that you're going to be responsible for the jury selection process, and that's also governed by court rules, which determine when you can appropriately challenge a witness.
Yes, sir.
Do you understand that in order to become a licensed attorney to practice in Michigan, it typically requires at least 3 years of law school and passing a bar exam to show that you have a sufficient knowledge to work as an attorney?
Not a part of the state of Michigan. I am the Republic of Michigan, Michigan Republic.
Okay, you understand that in order, if you wanted to have a license to practice law in Michigan, you would need to go to law school and pass the bar exam.
No, incorrect.
Wasn't thrilled. His expression said it all. He looked exhausted and probably ready to be anywhere else. Honestly, I don't blame him. And just like that, the hearing got pushed back again. No surprise there. My guess? He realized his usual tactics weren't working, so he tried to play along, at least for now. But chances are, when he comes back, he'll ignore everything his lawyer told him and go right back to quoting random things he saw online. Let this be.
Okay, you understand that the attorneys handling your case, the prosecutor is going to have a license to practice law in Michigan that meets the requirements that I've already indicated to you.
Which makes any judge or prosecutor or attorney a part of Great Britain, foreigners, only operating under their foreign sovereign immunity, which actually I have myself and trumps over all yours.
All right. I appreciate your objection to this court's jurisdiction, and I've ruled on that. And again, I'm not going to change the ruling. You can appeal that to the Court of Appeals in the Supreme Court if you wish at the appropriate time.
I'm gonna do that.
Do you understand that
Definitely.
at least in my opinion, I think you're going to be at a significant disadvantage in this case if you attempt to represent yourself with having a licensed attorney on the other side?
I already am. I'm dealing with the wolves. There's no fair trial in this military maritime courts. There's nothing fair about it. I mean, you've already made your determination the other day that I was not guilty. Last time I seen you in court. Let the record reflect that. I mean, you sit there and enter the plea and not guilty.
Sir, as I
You already
indicated,
said I was not guilty.
as I indicated to you at that hearing, I entered a not guilty plea for you. That is not my determination that you are not guilty of what's been
It's
alleged.
working from the bench, Your Honor. It's not your job to enter a plea. It's mine or my attorney's, which in this case it would be mine. So the court has already made a determination that I am not guilty.
All right, sir, are you sure that you want to represent yourself knowing all of the disadvantages, or at least what I believe to be the disadvantages that you face?
Yes.
And is that decision absolute and unequivocal?
Absolute and unequivocal.
Do you have any hesitation about the
And
fact that you
the
want to represent?
trial will be my peers. My peers will be secure party creditors.
Do you have any
That's gonna be
hesitation?
the jury.
Do you have any hesitation about the fact that you want to represent yourself?
Nope. No matter what you do to me, I will get out of it, and there will be lawsuits.
All right, at
Jobs
this
that have
point-
been-
At this point, I'm going to determine that Mr. Mattson has made an unequivocal request to represent himself. The right has been asserted knowingly and voluntarily after discussion advising him of the disadvantages of self-representation.
Mr. Daly,
And at this point, I will appoint
will Mr. Daly be willing to come over and talk to me here after we get done with this video screen
All right.
conference?
Yeah, I will appoint Mr. Daly as a standby counsel. And sir, you're
No.
asking,
Can I speak with him about a couple of things?
I can put you in a breakout session so that you can speak to him over video conference privately. If
Let me
you
do
might
that,
need-
please.
Okay.
A reminder, if you're in legal trouble, stick to real legal advice, not conspiracy theories or internet rumors. And of course, stay away from drugs. That combination is how you end up in videos like this one. Let me know your thoughts in the comments. Do you think he'll ever drop the act? Or is it too late for him to change? Thanks so much for watching. Take care and see you in the next one.